everyone. Today we have with us team comprising of Arjun Kapur and Taneja from MNLU Mumbai, who were adjudicated as the winners of the settlement agreement drafting competition organized by Symbiosis Law School. Firstly, big congratulations to you for your success in this competition. Before we begin
Thank
talking
you so
about
much.
your journey, I request you to please introduce yourselves to the audience.
Hi everyone. My name is Arjun Kapur. I'm in the third year, and I'm from National Law University, Mumbai. Tanisha, you can go ahead.
Hi everyone, I'm Tanisha and currently I'm in my third year of law school and we're from the same college.
Great. Can you tell us about the structure of this competition to start with, and also walk us through your approach to drafting the settlement agreement?
Yeah. So the structure of the competition was as follows. We got a dispute given to us between two dog companies on how they wanted to conduct projects, as well as like conduct parties for dogs and whatever, for dog parents as such. And we had to act like mediators in that. So we were not actually mediators, but we had to assume that the mediation settlement has already occurred. So after the assumption was taken into account, we had to create a settlement agreement which both the parties would come to agree on. And all this while, we had to make sure that the key principles of mediation and negotiation had to be taken into account while drafting that settlement agreement. Now, the approach towards the competition is something I think Tanisha can cover better.
So basically we hadn't participated in a settlement agreement competition before. So what we did initially was to go through a few settlement agreements and how settlement agreements look in general. And given that our dispute was fairly like a private matter, a private small matter, and we had to come up with creative solutions in it. So we were given a clear guideline by the college that you will be judged on these principles. One of them being that you have to inculcate creative solutions and ensure that the principles of mediations are there in the agreement, like essentially such as good faith, equity, and fairness. They have to be implemented in the agreement. So that's what we had done in our agreement.
Right. So what can you tell us about the key principles, or let's say strategies, that you use to ensure that the agreement that you drafted reflected the values of mediation?
So the first step that we ideally did was to identify the underlying interest and priorities of both the parties. So this process we call is Batna and Vatna, which is the best alternative available and the worst alternative available. So in a situation like this, we try to find out a solution that is beneficial to both the parties. And what is the key interest that the party does not want to let go in this negotiation, and what is the negotiated principles? So principles on which they can negotiate as well as give the other party that leeway and get the main essentials towards their side. So identifying these particular underlying interests is very, very essential to the first step towards understanding what settlement agreement means and how you approach the same. Now, coming to the second aspect that I personally feel was very important was ZOPA. ZOPA is the zone of potential. Tanisha, what is
Possible
that? Zone
agreement.
of potential improvement.
Possible
Yeah.
agreement.
Yeah. So the main reason that you try to identify ZOPA is why both the parties are here and what are the places on which they can agree. So that is something that we did initially. Moving on, Tanisha, if you'd like to add something to this.
So basically, just elaborating on what Arjun said, in this, just I'll give a little bit of context as to what the problem was to answer this question better. So there was a dispute between both the parties. They were in a joint venture earlier regarding conducting activities for dogs, and now the joint venture wasn't working out, so they wanted to go their own ways. Now, to go their own ways, being had to draft an agreement that they do not infringe upon the activities of the other party. Like while you're performing your own functions, you cannot perform the activities that the other party is already doing. Cannot take the same customers. So as Arjun said, that we had to identify a ZOPA, like what activities were already being carried out in the joint venture, and what activities cannot be carried out since by the party who has already left the joint venture. So what we did was we created new activities. We assumed that it's a real life scenario where we created new activities that the party who's leaving the joint venture can carry out, and keeping the activities that were already being performed in the joint venture to the other party. So this is what we essentially did to make our settlement agreement more structured in the form of keeping Vatna, Vatna, and Zopa in mind.
Right. Coming to the challenges part, what challenges did you encounter while drafting this agreement? And of course, how you overcame them? I'm sure there were some aspects like this, which you mentioned, which were very particularly difficult to draft. So how did you overcome it?
So a couple of challenges that we identified earlier on itself was that settlement agreement as such does not have any format in understanding, even in Indian jurisprudence, there does not exist a particular settled format that needs to be followed. So when we looked at settlement agreement, we tried to identify what essentials need to exist in a settlement agreement. And secondly, the page limit. So we had a page limit of around 6 pages, including the cover page. So we have to make sure that the whole dispute, as a solution to the dispute, the confidentiality clause, the dispute resolution clause, and all those essential clauses in the drafting agreement needed to exist in that particular settlement agreement. And that is was the most important part of our endeavor in this, to make sure that we had a very concise, as well as making sure that we didn't use too much legalese while drafting a settlement agreement, because we try to keep it very simple. So negotiation and mediation are something that we try to keep the legalists out of it when we also have this particular thing going on in real life itself. And we try to make sure that that same thing is inculcated in the settlement agreement also. I think as such, other than this, the lack of uh, mentorship that we had for settlement agreement in our college also was lacking, because no one else has done this particular competition or this format. So we try to make sure that we try to keep ourselves away from any external influence, while keeping in mind that we want to create a unique settlement agreement that can stand out from all the other participating colleges also. Tanisha, if anything that you feel that was there.
So yeah, main concern was standing out among other participants. Like, what can we do different that makes our settlement agreement different? So to answer this particular question is that, as I said earlier as well, that we named our activities that were being carried out. So a few settlement agreements were shared with us after the competition, depending upon their ranks. And what we noticed, that something that we had done different from that settlement agreement is that we were very specific with what one party gets. There was no area of vagueness or something that is left to, it's open to interpretation. It was very clear, concise, and the language was very crisp, and it was very simple to understand in our settlement agreement. And essentially what we did was, like, even if we are mentioning a part of it, we try to cover all the aspects that are usually there in a settlement agreement. Now, as I told you earlier, that we refer to a various set of settlement agreements, and we picked out points that are essential to be included in our agreements. We made sure that even if we mention like a line or two about certain aspect of an uh, agreement, let's say confidentiality or any other thing, we made sure that we include that in our agreement.
Right, along the same lines, as winners of this competition, what do you believe you set you apart from what all competitors you had? And you said you had the liberty to add innovative and creative elements to incorporate these elements in your agreement. So, how can you say you exercise this liberty? I'm sure only this is the way that you use it to your own advantage. So, what set you apart from others?
Uh, so for this creative solutions part is something that I think Tanisha can handle well. Other than that, what we did differently was this thing where we had a dispute on for like more than 10 days while drafting the agreement was a cover page. So on the cover page itself, I wanted to include, since it's a dog company and all of that, I wanted to keep it very informal and have a whole dog themed cover page and all those aspects. Then I wanted to keep it very subtle. There's a couple of dogs on the cover page. Then we asked other teams, like other people who have like worked in mediation firms, and then we asked them whether we should keep so many dogs, or say we should keep a couple of dogs. So all those things, even though it's a very, very minute thing that we noticed, was very important, because when we saw the runner-up, they did not have too much difference other than the solutions part of it, but the small things add on in a competition like this. Secondly, our dispute resolution clause was something that is very, very different from other teams. The dispute resolution clause in ours was a very layered dispute resolution clause. So first we had a pre-mediation clause in it, then we had a mediation clause in it, and then an arbitration clause in it. And this particular thing like really brought us away from all the other teams, because they had just mentioned that arbitration is the way to go about it when if the dispute arises down the line. So these small things on how precisely we drafted them, in keeping in mind the future repercussions of a settlement agreement and what it affects the party's interests, something that we wanted to keep in mind while drafting it, and the same reflected in even in a confidentiality clause, which was very properly drafted, that all the information that you have uploaded to the parties will be kept on a secured server, password protected. All these small things in the settlement agreement really added on to the legitimacy of making it seem that it was actually drafted by like people with a lot of years of experience in this particular field. Whereas solutions part is something that, if I'm not wrong, Tanisha can handle better because she drafted most of them.
Just to clarify, I did not want any dogs on the cover page. It's very informal. He wanted a lot of dogs. I didn't want
So
any
how
dog.
many dogs
What
were
we
finalized in the end?
No dogs were finalized at the end.
Right.
We just
Yeah.
added like a logo, like a fake logo of the institute that we are of. As
Right.
mediators, we belong
Right.
to a
Right.
certain institute. So we added a fake logo of that.
Right.
But apart from that, we first submitted a document with a lot of dogs, like 10, 12 dogs on it. But then we resubmitted it with no dogs on it. So to answer the creative solutions part, I believe that as Arjun also mentioned, that our settlement agreement was very structured and layered. And what we did essentially was we specified what party A would perform certain activities as, like in relation to dog, what activities can they carry out, maybe related to their overall health and well-being. And let's say party B can carry out certain activities which challenges dogs for dog championships or whatever. We had to be very creative with this because there is there in India, if we see, there are a lot of activities which are being carried out for dogs. So we couldn't take any real life example to write it in our settlement agreement. So we made it a little bit more defined as to terms of only a very minute set of activities can be carried out which pertain to a dog's health and overall well-being, and other party can maybe challenge them for sports championships and other arenas. So we made a clear specification as to that. And one essential feature that was specified in our guidelines was that we have to show a collaborative approach towards the future. So this part was drafted by Arjun, where he defined certain activities which can be collaboratively performed by both the parties in the future to show that there is still there's still a lot of relation between the party and it's not completely disrupted, to show that the parties still collaboratively want to approach towards settling the dispute by showing that they have some hope in getting again together in the future to carry out activities for the betterment of dogs. So this is essentially, we focused a lot on creative solutions, which set us apart, I believe, from other teams as well.
Right. Right, team. Thank you for being here. Your insights were very valuable, and I'm very certain that the audience will benefit greatly from it. Thank you once again for your time and generosity in sharing your experience. I, on behalf of IMCC, wish you all the very best for your journey ahead. Thanks again.
Thank you so much, Niharika, for this
Thank you for
opportunity.
having, sorry. Thank you for having us.